we talk about determination of incapacity, you have attorneys that do their best to make that determination for estate plans and things like that. You have doctors, you have judges, but there's also these real estate professionals, one of which is a title company, right? And when you're in a real estate transaction, generally you're going to be using a title company who's going to ensure that the buyer is receiving good title to the property. And there's what the law provides, such as what you dictated, Lou, which is, hey, if they're lucid, if they have a good day, a good time, they can contract and they could show up at the title company and be very capable of signing documents. Well, right. The title company may say, well, yeah, that might be what the law is, but we're not going to ensure good title to the buyer if we know that they have some form of, limiting condition as far as capacity goes, right? Alzheimer's or dementia or whatever. And so you could, in theory, have a situation where you have a very simple transaction, husband and wife, and they own it, community property with right of survivorship. Everything's good. They want to sell their property. They're going to downsize. They're going to do something, and they're ready to go. And the wife informs their broker or informs the title company or whatever that my husband's just been diagnosed with Alzheimer's. We want to downsize. He can't take care of this house anymore, et cetera, et cetera. And the title company says, well, time out. We're not doing this transaction. So now what are the options? How is this property going to be sold if the title company is not willing to let the wife sign?
Well, unless
the husband sign in that hypothetical,
unless you can convince the title company otherwise, and perhaps you might be able to get the husband's physician to, certify that he or she believes that this person has sufficient capacity. That might be enough. But what I would recommend in a case like that is we do have, as an alternative to a conservatorship, which is a long drawn out process, because in a conservatorship, not only when the person gets appointed, do they have to, A, post the bond, B, pay the court-appointed lawyer, pay their own lawyer, et cetera. But then they have to file an estate budget. They have to then every year they have to file an annual accounting, and it's a pain in the butt. I mean, it is not an easy job. It's not a job that I would volunteer to do. I will tell you that. But the alternative is that there is a process in probate court that allows the court to appoint a conservator for a single transaction. So if we had a property in escrow, and if we could keep the deal together long enough that people are patient enough, we could file a petition for a single transaction authority. The court will appoint somebody, probably the wife, with authority to close the transaction on behalf of the husband. And then as soon as it's closed, we can file a closing statement and tell the court we finished and we're done. So it's sort of an in and out probate, a lot less expensive because we don't have any of those ongoing responsibilities. And it's a way that we can get a deal done. So that would be the way I would probably recommend if a person came to me, whether it's the realtor or the client, and saying, hey, I need to close this deal. How do I do it? That's what I would recommend.
Now, in that type of transaction or probate, is there still going to be a court-appointed attorney for the ward?
No, it's really a truncated process because all you're doing is you're showing to the court that there's a single transaction. And, generally you're explaining that the property's in escrow, that the questions of capacity have arisen, and you ask the court to allow the spouse to close escrow without the husband's participation. And there's no court appointment, there's no budget, there's no accounting, there's no bond, none of that.
How long does that process take?
We can usually get that if I were filing that petition today, which means that I've had enough information given to me to be able to do that, we usually can have a hearing within 6 weeks. So if we can keep that escrow together for 6 weeks, we can probably survive.
Yeah. So the buyer just has to be patient. The sellers have to be patient, but it can get done in fairly short order as far as cost goes. and even time frame as opposed to, you know, the standard.
Yes, it's less expensive.
Yeah.
We, you know, again, it's an in and out kind of a deal. So yeah, overall, that would be the best way to go. And I've used it successfully. So it does work.